Good morning. Are you Brandon Henderson? And will your client waive the formal reading of the motion?
It will, Your Honor.
Mr. Henderson, in clause number 22-40931, I have a motion to revoke your community supervision. Shows that you were placed on probation June 13th of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges you violated your probation. Count 1 alleges that you committed the new offense of aggravated assault February 26th of 2025 in Montgomery County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of unlawful carrying a weapon in Montgomery County on February 26, 2025. And is that true or not true?
True.
Count 3 alleges that you did not provide verification of performing the community service hours as required. And is that true or not true?
No, that's not true. I did most of my community service.
Okay,
hours, so-
that's fine. Count 4 alleges that you are behind in your court-assessed fees. And is that true or not true?
True.
Count 5 alleges that you failed to remain in the state of Louisiana and that you were in Montgomery County on February 26, 2025 without permission.
True.
Count 6 alleges that you failed to report to the Jefferson County Probation Department by mail-in or online for the months of October, November, and December of 2024, and then January and February of 2025. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 4, 5, and 6 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
State,
Just so the court
Yes.
is aware, he received 2 years on the case in Montgomery County. That has been disposed of according to their office.
okay, thank you. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Henderson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your plea of true to those counts freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find counts 1, 2, 4, 5, and 6 true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That sentence will run concurrently or at the same time as your Montgomery County cases. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. All right, you're Kaylin Salzar. And Ms. Salzar is on probation in cause number 24, DCCR 2234, and that is for a misdemeanor offense or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court-assessed fees, that she admitted to using alcohol in violation of her probation August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kemmler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the 2 cases before you, she has 2 separate
DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from is what's listed in the motion. It looks like the only thing holding her is the bond on this case, and if she's in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask there be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. If she does have the interlock, I don't think she needs to be at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just going to put off. And so obviously if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without it being approved by probation and ultimately by me, so that we know
This is a crucial moment in the hearing. Notice how the judge immediately shifts the conversation away from promises about rehab and back to accountability. In probation cases, good intentions alone usually aren't enough. The court wants structure, supervision, and proof that the defendant will actually follow the rules. Do you think the judge is being fair here, or being overly cautious interview?
know what that is, where it is, and what that means with regard to that assault on a peace officer case.
That's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines.
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. You understand? Any other conditions that?
I think that should cover it.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
And so that's what your bonds.